Hi, I'm Jesse Roadside, an attorney here at Marzzacco Niven Associates. I help injured workers with their cases, and one of the most common questions I get is, how long do I have to report my work injury? Pennsylvania law is pretty clear. It says that in order to qualify for workers' compensation benefits, you need to tell your employer about the injury within 120 days from the date that you were injured or when you knew you were injured. If you don't, your claim can be denied because you didn't provide timely notice of the injury. Now, in many cases, that injury will occur in a single specific incident. For instance, lifting and then feeling low back pain, or suffering a trip and fall with a hurt ankle. Even if the injury is relatively minor, give notice right away. Explain that basic information like what you were doing, when and where the injury occurred, and what problems you're having to your supervisor. You'll have satisfied those rules. The best thing you can do is to report your claim immediately once you know you've been injured due to your work. If you don't report the injury promptly, the claims process can be delayed. You might not be paid for all of your lost time or have your medical expenses paid. Not all cases, though, involve a single specific incident. Some injuries can't be pinpointed to a single accident or event, but instead are the result of doing a job, perhaps for years, day in, day out, over time. When should you report your injury? The same basic rules apply. Once you know or should know that your injuries came about because of your work, you should report that injury to your supervisor. If you as a worker suffer injuries from the cumulative effects of your job duties or the environment, though, there are two main considerations regarding giving notice of the injury. The first question is that exposure continuing? And what we're looking for here is, are you still undergoing the same ongoing conditions contributing to your injury every time you go into work? If so, every day can be considered a new injury, and that'll extend the amount of time that you have to report the injury to 120 days from the date of last exposure. Of course, if at any time that you know your ongoing work is causing your injury, you should report it as soon as possible. The second major consideration is, when did you learn that the condition was caused by work? Particularly in cases involving repetitive trauma, you may have no idea why you're suffering pain. You can't tell your employer that your injury came from work if you don't know why you're hurting. Being told by a doctor, though, for instance, about the relationship of your medical condition to your work is enough to trigger your duty to report the injury. Many employers, it should be known, have policies regarding the immediate report of the injury, and indeed they may threaten disciplinary action if you fail to give immediate injury. While they may take some disciplinary action for failing to follow company rules, workers need to know it's illegal for an employer to retaliate against you for filing a workers' compensation claim, and regardless of the language in the employee manual, you still have 120 days to report the injury and be eligible for workers' compensation benefits. Remember, notice does need to be given to your supervisor or manager. Simply telling a coworker or telling your manager that you have aches and pains without linking that up to your work activities is not sufficient. Make sure you give notice to the right person, and that's your supervisor. Wrapping all this up, be prompt and be detailed. Tell your supervisor as soon as you know about your work injury, and that's true whether the injury was clearly caused by work in a single incident or if it was over time. If you know that it was caused by work, report that injury immediately. If you have questions about reporting your injury or other aspects of your workers' compensation claim, contact us today for a free consultation. Thanks.